Are you worried about how you're going to get a job when you return home? Or whether employers are even going to consider hiring you? This is what California's Fair Chance Act is all about. Let me tell you about it. When you go home and look for a job, you have the right to be judged on your work qualifications, not your past. My name is Brandon Butler, Assistant Deputy Director of Education and Outreach at the California Department of Fair Employment and Housing, California's civil rights agency. In California, we believe formerly incarcerated people deserve the right to participate in their community as a thriving member with access to employment, housing, and community resources. If you were locked up and did your time, you should not be locked out of society when you return home. That is why, under California law, it is unlawful for employers to ask or include a question about conviction history on a job application or ask about a past conviction prior to a conditional job offer. That means an employer can't ask you about your conviction history or run a background check until after they've already offered you the job. Remember the box on the job application that used to say, "Have you been convicted of a felony, yes or no?" Well, that has been banned. We banned the box in California. An employer can ask you about your criminal history or run a background check after they offer you a job, but they still have to follow some rules. The employer is never allowed to ask about things you were not convicted for or convictions that have been expunged or sealed. If you've been pardoned or received a certificate of rehabilitation, the employer can't ask about that either. If the employer wants to take back the job offer after the background check, that can only happen after the employer conducts an individualized assessment. That means the employer has to consider you as an individual person. They have to consider the time that has passed and how the crime you were convicted of is related to the job you applied for. If the employer is still going to take back the job offer because of your history, they need to send you their decision in writing, listing out the convictions they think disqualify you and provide you the conviction history report they base their decision on. Then you get 5 days to challenge the decision. For example, there might be something in the criminal report that's just wrong, or you can provide information to change the employer's mind, such as information about your work history, special circumstances that help explain your past crime, or education or training you've received. In other words, evidence showing that you can do the job and that your conviction history isn't relevant. If the employer is still going to take back the job offer after considering all the evidence, it has to be because your conviction history has a direct relationship with the specific duties of the job. For example, if a person was convicted of a felony traffic offense while driving a car, their conviction history would have a direct relationship to a job as a limousine driver. If the employer takes back the job offer, they need to let you know in writing that you can file a complaint with our office, the Department of Fair Employment and Housing, if you believe your rights were violated. At the Department of Fair Employment and Housing, we are here to help, and it's free. Call us at 800-884-1684 or TTY at 800-700-2320 or California's Relay Service at 711. Remember, we have banned the box in California. In California, you have a right to a fair chance to get a job, and the Fair Chance Act protects you. Thank you.